Dear students, and this time we are offering the course on the new labor codes of India. The background of this particular course to be offered is that the government come out with 4 new labor codes, and the first one is already notified, and we are waiting for notification of the other 3, which was made little bit late due to the pandemic. So, the labor empowerment is very important for the workers in this country. For the last 74 years, many governments were trying to improve, trying to repeal, trying to amend all the laws relating to workmen, or we would say that labor laws many times amended and many provisions are included. And the complete repeal of the labor legislations were on card for many governments after independence. So, it means last 74 years the governments from time to time come out with various provisions, and mostly our labor legislations are the British made. Most of the important labor legislations are British made. We are simply following, or we simply amended some of the provisions. But the complete repeal of these provisions are path breaking. It is completely going to change the entire scenario of labor legislation as well as ease of doing business in India. So, we saw that the first time the government is decided to provide complete social security irrespective of organized or unorganized sector to all workers in the country. So, we were waiting for this to happen after probably after the independence for more than 74 years. So, clearly we are starting. The objective of this particular class is to give you an idea about the objective of the course and also a background or introduction or highlights of these 4 codes. And we know that these particular legislations are mostly from time immemorial period labor legislations there are in the country. The Britishers, they made these laws in benefit of them, especially most of the legislations were in benefit of the industry, and some of them were in benefit of the workers. So, there is a set of law exactly the present government has codified or repealed 39 legislations into 4 codes. If you look into the objective of any labor legislation, the objective is very clear. You can say that mostly I would say that it is the labor welfare rather than workers welfare, and we can say that the complete set of rules, whether it is in the factories, industries, relating to social security, relating to wages, or relating to health and occupational diseases. All these are the welfare laws which is already made in the country, but elaborate provisions are included in the new code. After independence, most of the legislations are made in favor of the industry, because the governments, successive governments through the 5-year plans, they want the industries to grow in India. So, we can say that the 2 schools of thought. So, the scholar says that some of them are definitely in favor of workers, but most of them are in favor of industry, but it is not actually the case. So, this balancing of these rights and duties of or we can say that the social security measures for workers are going on for this particular period. So, most of the cases in India, the tripartism So, the employer, employee and the governments are in side by side working for the welfare of workers. So, we know that from the British time itself, the trade unions are formed. The freedom to form trade unions are allowed under the Trade Unions Act of 1926. So, thus a legally recognized unions can go on for the labor. So, they are free to have the bargaining power. The collective bargaining power is with the labor unions. So, basically the labor law making a balance between the rights of employees and employees. These are including permanent workers, or we call it organized sector, unorganized sector, contract workers. Then in legal terms or legal parlance we call it for hire, or so now the new the slogan is hire and fire. So, through this particular codes we will see that. So, what is really the objective of these new codes? What was the objective of amending the existing laws? So, basically labor law provides a framework of rules and regulations for employers, workers, their representatives like trade unions and those who are related to the industry, the working industries. And industrial relation is one of the important factor in the workplace. So, if there is no working environment in the industry, so it is going to be severely affect the economy of the country. So, it is very necessary that there must be a labor friendly environment in the country. And we know that most of the rights are embedded in our constitution in the form of fundamental rights, in the form of directive principles and other labor legislations. So, basically the labor laws which establishes legal systems, rules, regulations for employees as well as employees, and to keep a productive workplace environment. So, if we look into the new codes, we know that the new codes are directed towards the Atmanirbhar of workmen. This is the Prime Minister's words. So, the labor welfare is an integrated element of constitution of any democracy, that is especially India, the largest democracy in the world. Since opening up of our economy in 1991, mostly the industry is asking for amendment of these labor legislations, but we have a very strong setup of labor laws even prior to 1991 in the country. So, for example, some of the legislations are very old and amended in 1948 like Factories Act, which clearly gives the complete management of factories in the country, factories and the workers in the country, their working conditions and the workplace hygienes and workplace dignity, livelihood and the duties of employees, and what are the duties of employees, what are the benefits, health, occupation, etc. So, our directive principles of state policy elaborately talks about it. In the coming classes, we will deal with the directive principles elaborately. When we look into the administrative system, we have the Ministry of Labor and Employment and also many wings, one of the largest ministries in the central government, and the workforce working for the welfare of workers in this country. So, simply you can see that what are the the branches, the various branches of this Indian ministry, and under the ministry you can see that they manage and they administer the labor laws in this particular country. As such, labor is in the concurrent list of the Indian constitution. The state governments and the central government have the authority to legislate upon the particular matter of labor, that labor reforms. So, especially in the union list says entry number 55. So, specifically dealing with mines, oil fields and mine safety. Entry number 61, which talks about the industrial disputes concerning union employees. Industrial Disputes Act 1947 is one of the important legislation in the post independent India to the resolution of all disputes. Entry number 65, union agencies and institutions for a professional, vocational or technical training. So, this is exclusively you can see that the union list. In the concurrent list, we have trade unions, industrial and labor disputes. So, state governments are an important component of administering the Trade Unions Act, Industrial Disputes Act, Factories Act, etc. And entry number 23 dealing with social security, social insurance, employment and unemployment. We can see that the earlier legislations of provisions for provident fund, provisions for ESI under this particular heads. So, the ESI is exclusively managed for managed by the state governments and the central government with the help of central government. Entry number 24, which talks about welfare of labor including conditions of work, provident funds, employees liability, workman compensation and other pension schemes, maternity benefits and etc. So, these legislations are also managed by it is in the concurrent list, both the state and the central is empowered to make laws on these particular subjects. So, if you look into the legislations, you can see that the labor laws completely enacted by the central government, it is the sole responsibility of enforcement is with the central government, and labor laws are enacted by the central government, but enforced by central as well as state governments. Third category is the labor laws enacted by the central government, enforced by the state government, and fourth is labor laws enacted and enforced by various state governments which apply to the respective states. We can find state specific legislations as well. So, for example, earlier the construction workers, the law relating to construction workers are confined to some of the states, and later the central government has enacted the law, and now there are elaborate provisions in the new codes. And if you look into the other the parts of the constitution, part 3 specifically deals with the fundamental rights. So, fundamental rights which provides prohibition of discrimination based on religion, caste, sex, place and place of birth, equality of opportunity in the matters of employment, protection of rights regarding freedom of speech, protection of life and personal liberty, and prohibition of traffic in human beings and forced labor, prohibition of employment of children in factories, then the enforcement of rights, especially under this particular part 3 of the constitution, the fundamental rights. And also we can see that part 4 of the constitution, the directive principles of state policy, very clearly says that certain principles and policies to be followed by the state when they are enacting labor legislations: right to work, to education and to public assistance, provisions for just and human conditions of work and maternity relief, living wages for workers, and also participation of workers in the management of industries. So, the tripartite system is a part of this particular objective. Then duty of the state to raise the level of nutrition and standard of living to improve public health. So, the part 3 and part 4 of the Indian constitution, which gives the mandate to various legislations which was enacted by the different governments later. So, when we come to this particular course, the objective of the course is very clear. So, I would say that each and every worker in this country or employee in this country must know these particular provisions for various aspects of industrial relations, labor welfare enactments, and especially pre-independent and post-independent India, and I would say that the pre-codes and the post-codes. So, now the new 4 codes are going to be enforced fully. So, the present government, as we said, that they are committed to reducing doing ease of business and simplifying the social security legislations, which they were talking about this particular objective from the last government. So, ultimately the consolidation of these 29 laws are happened into 4 labor codes. So, this is going to be a path breaking, or you can say that an innovative initiation of the present government in the industrial laws of the country. This have long lasting impact on not only on the economy, at the same time for the welfare of organized and unorganized workers. So, the government has already said its intention to implement all over the country, including Jammu and Kashmir. So, the present course is a detailed study of all the labor codes or 4 labor codes, and which is going to be implemented in the country. And it is very important, it is very important to know each and every worker on not only their rights, their duties, the employer, what are the provisions, what are their duties and what are their rights, and what are the regulations, what are the benefits available to the workers, and also most importantly the dispute settlement system, which is provided in the new codes. So, the focus of this particular course is the applicability and implementation of the provisions and its impacts and its welfare measures on the workers. So, I would say that all workers, all employees, managers, they must know the provisions of these new codes. I am very sure that all these class of people are going to be benefited. So, these particular codes are enacted by the government with the vision of the Honorable Prime Minister, minimum government, maximum governance. So, this slogan is as part of, we can see from the part of the Atmanirbhar Bharat. So, the Prime Minister has very clearly said, so Sabka Saath, Sabka Vikas or Sabka Vishwas. So, these are some of the slogans. Now, it is very soundly so hearing in this particular country. That is why these labor legislations are consolidated into 4 labor codes. So, India has improved its, these reforms are improved to reach the Indian position on the ease of doing business, and the 4 labor codes completely ended the inspector Raj system. So, the labor inspectors are not to be in future as facilitators, they are not only inspectors, they are facilitators. So, their role is completely changed. So, every government wants to do something for the unorganized sector, which constitutes around 90% of the workforce in this country, and the government estimates that they are constituted 40 crore workers in this country in the unorganized sector. This is the first time that the present government is thinking of providing all benefits which are available to the organized sector is to unorganized sector as well. That means, there is no discrimination between the benefits under these 4 codes to the organized sector and unorganized sector. So, if we will come to the 4 codes, especially the first code is the wages code, the code on wages 2019. This first code is already notified and this is enforced into law. So, this is the law. The present law is the code on wages, which actually contains the 4 legislations, earlier legislations. The name itself says the code on wages, the Payment of Wages Act 1936, the Minimum Wages Act 1948, the Payment of Bonus Act 1965, the Equal Remuneration Act 1976. These 4 codes are repealed into the codes on wages. So, if you look into this particular code, you can see that there is a consistent definition of wages which is given in the code, and also the industry must know that what is included in the wages and what is excluded in the wages. Now, the new wage code universalizes the minimum wage across the establishments, organized and unorganized sector, and also provided for review of the minimum wages every 5 years. So, in order to, especially one of the provision is included in the wage code is in order to completely remove the disparity, regional disparity. Presently, the state governments are deciding the minimum wages. So, there is a lot of disparity among the states on minimum wages. So, the code wants to remove this disparity and wants to put a national floor wage, where the state governments won't be able to fix the minimum wages below the national floor wage. And the ceiling of the minimum wages has been increased from 18 to 24,000 even much before notifying this particular code. So, the ceiling also has been increased, and also you can see that the wage code provides a separate definitions for worker and employee, and employee have a wide connotation, which includes each and every working people. At the same time, you can see that it fixes certain exclusion limits also. So, the remuneration now paid by the companies. So, we can see that the corporate sector says that this have an implication, and an exclusion limit is put on the minimum wages. So, usually the companies give a very low they show that a minimum wages or minimum wages as the basic wage, and they give us more of other allowances. Now, the companies won't be able to give too much allowances exceeding the exclusion limit that is fixed as 50%. So, the excess of exclusion limit will be treated as wages. So, there will be more contribution towards the social security legislations like the provident fund. So, again this is in this background, it is very important to see the judgment of, in this particular case, the Gujarat Mazdoor Sabha and another versus state of Gujarat. The decision is on the background of the pandemic. Can you put the complete burden of the lockdown around for a period of 2 years on the workers? So, the court, the quoting Granville Austin, it states that the conscience of the constitution that connects India's future, present and the past is by giving strength to the pursuit of social revolution in India. It was compelled the court to say this because there was the overtime working has put on the workers, and the particular notification of the government says that the workers are eligible to get the overtime wages in accordance with their proportionate to their salary, rather than the law which is existing than double the salary. So, the Supreme Court clearly upholding the constitutional values and morality, by clearly saying which is fundamentally which is clearly pointing out the directive principles of state policy. So, vision of a welfare state. So, the court says justice, social, economic and political the upliftment, looking into the workers upliftment. The court said that the burden of the pandemic should not be put on the shoulders of workers. So, elaborately it says the economic security of workers during the pandemic to be enforced. So, this particular judgment is also have an impact on in future also. So, no exploitation of workers, no exploitation of workers even during the pandemic time. So, there may be problems in the industry which is beyond our control, but that burden cannot be put on the workers, because our constitution or statutory provisions, the conditions and the exemptions and the wages is in accordance with the directive principles of state policy to eliminate and for promoting dignity and equity in the workplace. So, the government cannot come out with notifications under some other law like Disaster Management Act to overturn the provisions of the labor law. So, the second industrial code is the Industrial Relations Code, which amends 3 legislations, that is the Trade Unions Act 1926 and Industrial Employment Standing Orders Act 1946 and the Industrial Disputes Act of 1947. This Industrial Relations Code of 2020 is consolidated completely the laws relating to the settlement of the settlement of industrial disputes. The next class we will see that the new arrangements which are made online for the settlement of disputes by the government. So, here some of the new entrants, like for example, the journalist and newspaper employees and sales promotion employees are within the purview of the Industrial Relations Code. So, is the most importantly the industry was asking for a long period of time the fixed term employment which was made legal. So, this code, is the formation of negotiating trade union, a single negotiating trade union for each and every industry, which will reduce the hassle between the employer and employee. And also it provides for the grievance redressal committees, and also the standing orders are made compulsory for more than 300 workers. So, the numbers are increased. So, now for going for strikes and lockouts 60 days advance notice is required for and especially when the closure of industry, only 60 days again notice to the government is also required. So, the gratuity is provided to the even the fixed term employment, and it is not only gratuity, it is ESI and provident fund bonus and almost all the benefits which are available to the organized sector is available to the unorganized sector as well. The third code is the Social Security Code. The Social Security Code consolidates 9 legislations, that is the Employees Compensation Act, the Employees State Insurance Act, the Employees Provident Fund and Miscellaneous Provisions Act, the Employment Exchanges Act, the Maternity Benefit Act, the Payment of Gratuity Act, the Senior Workers Welfare Fund Act, the Building and Other Construction Welfare Cess Act 1996, the Unorganized Workers Social Security Act. The 9 legislations are consolidated in the Social Security Code, and we can find some new definitions in this particular code, and we will deal elaborately with these definitions in the later classes. And the fourth code is the Occupational Safety and Health and Working Conditions Code 2020. The single code, this repealed 13 legislations relating to factories, plantations, mines, working journalists and motor transport workers, BD and cigar workers, contract labor, sales promotion employees, interstate migrant workers, senior workers, dock workers and building and other construction workers. So, all these legislations are consolidated in the Occupational Safety and Health Code. So, the code expanded the definitions, some of the definitions, and also the applicability to there is more number of workers, those who are working, and the Social Security Fund, a fund is organized under this particular code as known as the Social Security Fund for the unorganized workers, gig workers and other platform workers. And the national social security is provided to these highly unorganized sectors as well. So, the women are be entitled to be employed in all establishments for all types of work, and special provisions are provided for interstate migrant workers, and also special benefits like travel allowances are provided to the interstate migrant workers for the first time in the country. And the code fixes daily working hours limit to 8 hours, and also the Occupational Safety Code, which provides for constitution of National Occupational Safety and Health Advisory Boards as well. So, these codes elaborately deal with the factories, Social Security Fund, the contractors, and also the other benefits which are available to the workmen. And the code prohibits employment of contract labor in core activities of any establishment. So, special provisions for audio visual workers and common workers, the common provisions for BD and cigar workers are provided. So, we can see that this particular code is going to change the labor scenario in the country. So, I am very sure that this course is going to be benefited for all the workers in this country. Thank you.